It's a bizarre case, so it's worth just running down to see how badly awry some of these cases can actually go. It was filed in June of 2006. It's in the District of Maryland, and it's before Judge Alquist. The debtor was a long-defunct mechanical contracting company. It had gone out of business in 1976 and started getting sued in the 80s for asbestos claims. It had lost all of its documents in the meantime and had to try to reconstruct its coverage chart. At the time of the petition date, there were 20,000 claims pending. Almost all of them were filed by Peter Nickel and Peter Nickel firm and the Peter Angelos firm with about equal numbers. We had on and off again coverage litigation between the debtor and Maryland Casualty primarily for 20 years. And then we had a pre-petition deal between Maryland Casualty and the debtor without any involvement from the claimants. The debtor then wanted to share that deal with the claimants. The idea was that the settlement would be used as a foundation for a Chapter 11 plan, whether a liquidating a reorganization plan. So it was presented to the Angelos firm, and they had this reaction. They went in and sought a TRO to try to prevent it, and the next day Lloyd E. Mitchell filed for bankruptcy. Lloyd E. Mitchell and Maryland Casualty then filed a motion seeking approval of the settlement. We had an ad hoc committee that was formed in the case, made up of Angelos clients and Nickel clients. They filed a motion to dismiss, and they had a discussion then between the debtor and the committee, and what happened was the 9019 motion was withdrawn, and the motion to dismiss was withdrawn, and then that was followed by a liquidating Chapter 11 plan, which was not particularly insurer-friendly. So the insurers objected to that plan. We objected to the amended plan. And then we had a confirmation hearing scheduled twice, and the debtor and the committee asked that it be postponed both times. We had a failed mediation between the insurers and the committee, and then coverage litigation resumed. This was originally attempted in the context of the bankruptcy with an adversary proceeding. It was dismissed on abstention grounds, and that was affirmed on appeal. And then leave from the stay was granted so that Maryland Casualty could sue the debtor and the other insurers, as well as putative class defendants, which is a little bit unusual. At that point, the debtor and the committee declared victory, and they withdrew their plan and filed a motion to dismiss the case. The two insurers then opposed the motion and asked for a trustee to be appointed, and then the insurers filed a Chapter 11 plan. And then there was a hearing on the trustee motion last fall. It was taken under submission by Judge Alquist. The coverage litigation then went wild for about 6 months in discovery, and then the same two insurers that filed the plan have now settled, not with all the claimants and not with the debtor, but with the Angelos firm. And where we are today is we have a bankruptcy case pending and we have a coverage case pending, and both of them are stayed. I think the interesting thing with this case is obviously the shifting alliances, and I think the next move is really going to be Peter Nickel's move in terms of what he does, whether he tries to interfere with the settlement either in the context of the coverage case or in the bankruptcy case. But I do think that at this point, all of the assets in the estate are depleted, and I think that the bankruptcy case will be dismissed in fairly short order.